Now, the trial within a trial in the Senzo Meyiwa murder case resumes at the High Court in Pretoria this morning. Now, it's all to do with confessions by two of the accused who claim that they gave their confessions under duress. You will remember last week the judge ruled that a recording of the alleged confession cannot be admitted as evidence. He found that Bongani Ntanzi was recorded without his consent and therefore his rights were violated. Our reporter Manqoba Mchunu joins us from Pretoria. Manqoba, a very good morning to you. It was a very dramatic week in court last week. Perhaps let's start off with a recap of exactly what transpired in court.
Well, Tommy, the issue last week really was about the audio recording of accused number 2, Bongani Ntanzi's alleged confession that we now know happened on the 24th of June in 2020. This is when he had then approached a magistrate saying that he had wanted to make a confession on this particular case, and we understand that from that statement that he had then given to Magistrate Vivian Cornea, she had recorded that particular statement, but what had transpired is that she had then admitted in court that she had in fact not asked or had told accused number 2, Bongani Ntanzi, at the time that she had in fact been recording this particular confession. It came to light in court last week during her evidence in chief. And of course, the defense had then opposed this particular audio recording from being used as evidence in the trial within a trial. Their reasons were that this was in violation of accused number 2, Bongani Ntanzi's rights. They argued that particular point on Thursday when that application was then heard by the court. And what the state had indicated is that they wanted this particular audio recording to be made as part of the proceedings or to be admissible as evidence in the trial within a trial, simply because they're saying that it was an electronic version of that particular confession. But I think the issue was around the fact that Ntanzi at the time was unaware that this particular recording was being made, and so the defense had then objected to this particular recording being used as evidence in court. And what it contained is that confession that was made by Ntanzi as far as the case is concerned, but also the filling in of what is known as a pro forma document. This is a document that lists the rights of the accused just prior to him making that particular confession. You know, there's a checklist that is done as to whether he is doing this freely and voluntarily, and also whether he is aware of his rights to remain silent and not to incriminate himself. So he says that he was not aware that this recording was made, and ultimately the court then ruling that using this particular recording will be a violation of his constitutional right. And it based this on Section 35 of the Constitution, which speaks to how evidence is obtained, and that evidence that is obtained unlawfully should not be used in a court. But let's take a listen to that ruling that was given by the judge when reaching his decision.
If this court allowed such an egregious flouting and flagrant flouting of accused number 2's constitutional rights in terms of Section 35(5), it would not be in the interest of justice to do so, because accused number 2 would then be continuously subjected to a trial unfairly.
Now, Magistrate Vivian Cornea's cross-examination will be continuing today. What did we hear on Friday?
Well, essentially what we heard from the defense is a rebuttal of some of the evidence that Magistrate Cornea has given to court. You recall that she had indicated that Ntanzi was happy, he was calm, he was relaxed when he had made that particular confession. He was in the presence of his lawyer, Mr. Dominic Mjiako, who was also part of those proceedings. But Ntanzi actually saying on Friday that he was not represented by a lawyer and that he did not know Mr. Mjiako Nako, he also refused or rebutted claims that, in fact, he had done this, willingly, saying that at the time when he gave this confession, he had in fact been tortured. We understand he'd been tortured 4 times, at 4 different places rather. And he says that this happened, the confession that is, after he had been assaulted. So his claim is that he had been coerced into making this particular confession. He also says he did not sign that particular document that contained the statement and that particular confession. And what he seems to suggest, of course, is that this was all part, of forcing him to make that particular statement. Is crucial in this trial within a trial, because this is exactly what it's trying to find, whether or not that particular confession was made under duress or whether there was any sort of force applied to him to make that confession. And this is what the court will ultimately decide, whether or not to accept this particular confession as evidence in court. And this will be based largely on whether or not there was that assault, there was that pressure that was applied to him to make that particular confession. So we're expecting Magistrate Vivian Cornier to continue being cross-examined this morning, and we also understand that the lawyers for accused number 1 and 2 are also likely to reopen their cross-examination this morning, but also lawyers for accused number 3, 4 and 5 also expected to pose questions to some of the evidence that she's given in court. And also we hear that possibly another witness is then likely to take the stand, and this time we expect an interpreter who was also present when that confession was taken to be called to testify in the stand.
Manqoba, we'll leave it at that for this morning. That was our reporter, Manqoba Mchunu. Certainly you see why this is called a trial within the trial, actually getting into the merits of the case, getting into confessions, etc. A little bit of a complicated way around this, because we don't usually actually see this happening in the courts of law.
A trial within a trial, very, very complicated. The question is going to be now, when does that trial within a trial end and the trial per se, the trial proper, continue again, with everything coming out of that?